Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in Quarles versus United States, certiorari to the United States Court of Appeals for the Sixth Circuit. Argued April 24th, 2019. Decided June 10th, 2019. When petitioner Jamar Quarles pled guilty to being a felon in possession of a firearm in violation of 18 U.S.C. section 922G1, he also appeared to qualify for enhanced sentencing under the Armed Career Criminal Act because he had at least 3 prior violent felony convictions, section 924E. He claimed, however, that a 2002 Michigan conviction for third-degree home invasion did not qualify, even though section 924E defines violent felony to include burglary, and the generic statutory term burglary means unlawful or unprivileged entry into or remaining in a building or structure with the intent to commit a crime. That's Taylor versus United States. Quarles argued that Michigan's third-degree home invasion statute, which applies when a person breaks and enters a dwelling or enters a dwelling without permission and at any time while he or she is entering or present in or exiting the dwelling, commits a misdemeanor. That's Michigan law, section 750.110A, 4A. He claimed that law swept too broadly. Specifically, he claimed, it encompassed situations where the defendant forms the intent to commit a crime at any time while unlawfully remaining in a dwelling, while generic remaining in burglary occurs only when the defendant has the intent to commit a crime at the exact moment when he or she first unlawfully remains in the building or structure. The district court rejected that argument, and the Sixth Circuit affirmed. The Supreme Court held, the decision below is affirmed, and Justice Kavanaugh delivered for a unanimous court. Generic remaining in burglary occurs under section 924E when the defendant forms the intent to commit a crime at any time while unlawfully in a building or structure. In ordinary usage, remaining in refers to a continuous activity, and this court has followed that ordinary meaning in analogous legal contexts. See United States versus Quarles. Those contexts thus inform the interpretation of remaining in burglary in section 924E. The common understanding of remaining in as a continuous event means that burglary occurs for purposes of section 924E if the defendant forms the intent to commit a crime at any time during the continuous event of unlawfully remaining in a building or structure. The intent to commit a crime must be contemporaneous with unlawful entry or remaining, but the defendant's intent is contemporaneous with the unlawful remaining so long as the defendant forms the intent at any time while unlawfully remaining. That conclusion is supported by the body of state law as of 1986, when Congress enacted Section 924E. Quarles' narrow interpretation makes little sense in light of Congress's rationale for specifying burglary as a violent felony. Congress singled out burglary because of its inherent potential for harm to persons. That's Taylor. And the possibility of a violent confrontation does not depend on the exact moment when the burglar forms the intent to commit a crime while unlawfully present in a building or structure. Quarles' interpretation would also thwart the stated goals of the Armed Career Criminal Act by presumably eliminating many states' burglary statutes as predicate offenses under Section 924E. For the court's purposes here, the Michigan home invasion statute substantially corresponds to or is narrower than generic burglary. The conclusion that generic remaining in burglary occurs when the defendant forms the intent to commit a crime at any time while unlawfully remaining in a building or structure resolves this case. When deciding whether a state law is broader than generic burglary, the state law's exact definition or label does not control. That's Taylor. So long as the state law in question substantially corresponds to, or is narrower than, generic burglary, the conviction qualifies. The decision below is affirmed. Justice Kavanaugh delivered the opinion for a unanimous court. Justice Thomas filed a concurring opinion. If you'd like to get a hold of the podcast, we can be reached at RhoadesScholar80, that's ROADS and 80, at gmail.com, or on Instagram or Twitter at Court Syllabus. Thank you.